I want to share with you this presentation about protecting your assets from me because I have a lot of experience, of course, as a personal injury attorney, because I've been doing it for over 30 years, but also because I've been a real estate investor, and so I've been on the other side of the process. And my purpose and expectation is to give you kind of the perspective of asset protection from my end, but both as a personal injury attorney, potentially the person pursuing your assets, and also as an individual investor, both in various forms of assets, including real estate. So hopefully I can give you both of those perspectives. I'm going to try to make this as fun and informative both as possible and run through the presentation. And then at the end, I'll have as much time as you'd like in order to answer any questions that you have. So please write down your questions. I'd be absolutely available for as long as you need me to. I'm glad to answer all the questions that come up. So with that, let me go ahead and get you started. I should mention for those of you that don't know me that, as I mentioned, I've been doing personal injury law for a little over 30 years. Graduated from University of Pennsylvania undergrad and Duke University for Law School. Started off as a real estate attorney with visions of becoming a real estate developer, but didn't go in that direction and ended up in my own law firm doing only auto accidents, medical malpractice, and premise liability. So I want to describe to you the problem that you'll face in regard to protecting your assets from folks like me and in general. One is that we, of course, are a more litigious society than ever. So people are a problem. It is, in fact, getting worse. And if the economy continues to do poorly, there may only be more people that have an interest in seeing the legal system as an opportunity to try and improve their standard of living or maintain their standard of living. We certainly are increasingly a litigious society. So if you thought that before, it is not your imagination. Certainly the advertisements being done by personal injury attorneys throughout the country, and particularly in Florida, things such as in a wreck, need a check, that doesn't bode well for making the public think, if I have a problem, if somebody's wronged me, the very first thing I should do is sue somebody. The other problem is people like me, attorneys. We're not employed to make ethical and moral decisions about our clients. I happen to be blessed with a great group of clients who are injured and need help in all sorts of different ways, and we provide them that help. That is not to say that every once in a while in my own practice, let alone others that do personal injury law, we don't get folks who stretch the truth, that don't necessarily have clear liability, but yet want to pursue damages. And it's our responsibility, heck, it's our obligation and oath to the Florida bar in the state of Florida and the courts to represent these people and advocate for them and not to judge them. That would be something that would go against our professional code of ethics. And so we have to look for every opportunity to represent their interests. And of course, juries can be a problem. For the most part, the jury system is an awful system for deciding issues involving civil litigation and personal injury or any other business matter for that matter, except that it's the best system that humankind ever came up with for getting these issues resolved. For the most part, I find that juries come to appropriate decisions with regard to the issues that they're presented. But there's certainly many times that the jury will make decisions and we'll interview them afterwards, and what they'll tell us, like, did you not hear the evidence? Or they will go ahead and use their emotions to make decisions, even though the judge will tell them to focus on the facts. And so it is an issue that sometimes, not regularly, but juries can get carried away with their verdict awards. There are things that the judges can do to minimize that kind of issue. But certainly between the people in general being more litigious, attorneys who have to zealously represent these people, and the possibility that the jury will find in a manner that is exorbitant, at least relative to what you think is appropriate in terms of damages, are issues that have to be considered, and a reason why we're having this discussion today, and you may be very well concerned about protecting your assets. I want to briefly talk about the problem areas. They are auto accidents, property ownership, professions and business ownership, and recreation and hobby. So let me go ahead and start with what many people are most concerned about, and that is driving and automobile accidents. Most people know that if they're in an accident involving a motor vehicle and they're driving that vehicle and they cause injury to somebody from their own negligence, that they're responsible for the damages that they cause. But what you may not realize is there's a lot of other types of ownership issues or damages that can come about. For example, just by owning the vehicle. You do not need to be a driver. In the state of Florida, your automobile is considered to be a dangerous instrument. And as a result of that, just by owning your vehicle, even if you're not in the car at the time of the accident, you could be held responsible for damages. So let's say you have a child in college and they come home from school and you lend them your automobile, or a friend says, boy, I need your automobile just for 15 minutes to get to the place that's repairing my car, or any other situation where you place somebody else in the driver's seat, you are held responsible just because you own the car. There's potentially limits to that. The damages are $100,000 per person, $300,000, no matter how many people are injured in that auto accident. But it goes up to an additional $500,000 if the person you let borrow the car doesn't have $500,000 worth of bodily injury insurance, which most people don't. The other issue is negligent entrustment, and that goes outside of what we just talked about, this dangerous instrumentality. And if you entrust somebody negligently, somebody that you know is a poor driver, somebody that had a history of auto accidents, you can be held for much more outside of even those statutory limits that I mentioned, just for owning the vehicle, but negligently lending it to somebody else. The other area is property ownership. Now, most of us, when we think about property ownership, we think about just being the owner of a property, having our name on the title of a property. But it also applies to if a landlord. So, if you're renting the property out, one of the things you might say, that's the tenant's issue, not mine. I didn't cause a problem in that home. I gave my partial ownership. I own the title, but I gave control over that property to somebody else. And people think that they're free of liability in that situation, when for a number of reasons we'll talk about, they're not. And then you may just be a tenant in a property and think, well, the owner, the person who I pay my monthly rent to, they're the ones who are going to be responsible if somebody hurts themselves on my property or otherwise gets injured. And that's not true. As a tenant, you have ownership rights. They're different than title ownership, but you have a lease agreement that puts you in a ownership type of position. And your job, your duty as an owner is to provide a reasonably safe environment for visitors. And the issue is that word reasonably. So, there's a lot of things that people say, well, I didn't know about that. Well, you should have known about it. Or that wasn't my fault, that was your fault. Well, that's something that ultimately a jury may have to determine about whose fault it really was. So the word reasonably safe environment opens up an opportunity for consideration of issues that may ultimately have to be decided by a jury. One of the areas is dog ownership. You might say, well, gosh, my dog is well behaved. Well, sometimes maybe they're not. Or you might say, my dog is well behaved as long as you don't put fingers in front of his face, or as long as you don't smack him on the side of the head. Well, regardless of what may have prompted your dog to bite somebody, in Florida, you are held liable. It's called something called strict liability. Now, you may be able to, in court, bring up, well, they put fingers in front of my dog, or I told them an hour earlier to stay away from my dog, or they they slapped my dog for some reason that I don't know. You know, they were aggressive with my dog. They were playing aggressively with it. All those things can be considered by a jury, but you're automatically liable if your dog causes injuries just because you own the dog. Now, you may think, okay, I hear what you're saying, Dale. I don't have a dog, but my tenant has a dog. And in that situation, you could be held liable too, because you are the owner of the property where the dog has, where there's a dog and there's an ownership there. And you may say, well, Dale, you know, I'm even doing one better. I told the tenant, and it's in the lease, that they can't own a dog. So I have no issues with concerns about dog ownership. And that could be true, except that in court, a attorney will say, you know, you said that they weren't supposed to have a dog, because you know dogs can cause bites. They can cause significant injuries. And yet they had a dog, didn't they? And that dog did bite somebody. So what did you do to make sure that they were honoring the lease that said that they shouldn't have dogs in there? You obviously could have made yourself aware, and yet you didn't. And now we have somebody that has significant damages as a result of a dog bite. So there's a lot of ways that, you know, you can be held liable, even if you have a tenant, and even if you told the tenant, have a written release that they're not supposed to have a dog. Here's another one that is very difficult to avoid liability on. It's called a nuisance law. There is in Florida a law that says that if you have an attractive nuisance on your property, that you can be held liable if a child hurts themselves. So for example, if you have a pool, you say, well, you know, I have a pool, and you know, there's a gate up there, and I don't have any responsibility. My kids are older. I don't have to worry about it. And even if I have younger kids, you know, I have a special lock on my inside door, so I'm good. Not so. If there's a child that figures out how to get into your property and then drowns or otherwise injures themselves running on the wet tile, you are going to be held potentially responsible for that under attractive nuisance law. You, as the owner, have the responsibility to keep these child trespassers out of your own property. Now, you may say that's not fair, but it is the law. So, you know, when you think about these kinds of things, you may add extra protection, but sometimes there's just no way. A crafty child wanting to get into your pool on a hot summer day may figure out a way to get into and hurt themselves into your pool. The same issue exists if you do things like, let's say you throw out a washer and dryer that has a door that seals, or a refrigerator, and the kids think, oh, you know, look, our neighbor's throwing that out. It looks like fun. Let's go and play. And they lock themselves into that washer dryer. You can be held for responsible if they injure themselves, because that's considered to be attractive nuisance. Or what if you have boxes because you just moved in or moved out, or you want, you know, until the waste comes, there's a box outside that had furniture in it, and the children start playing with that box and injure themselves. Again, that would be considered an attractive nuisance, and a lawyer can hold you responsible. The other issue can come about in ownership when you do repairs. Now, most of us want to do repairs as inexpensively as possible. Unfortunately, that can open you up for liability. We don't often ask people that say they can repair something whether they're appropriately licensed, but if they repair something incorrectly and they end up hurting somebody on one of your properties, whether it's your own home or a rental property, you can be held liable for that, because you have the responsibility to make sure these people did the work appropriately and were licensed. The other thing is true if you don't get permits, which is one way that people that do rehab work try to save significant amounts of money by not getting things permitted. That means that the city never has an opportunity to examine the work of that contractor. And as a result, if there's an injury, you can be held responsible for that. There's also, as we talked about before, that reasonableness standard. So you buy a home, for example, and you're living in the home and there's no problems, but all of a sudden somebody hurts themselves on a piece of wood or a board or flooring that is soft, and they fall through the flooring, or something drops from the ceiling And they say, well, I didn't know about that. I live here and there's no issues with it. And then comes up the issue of, should you have known about it? You live there after all. You could have hired a home inspector and maybe they would have found the problem and my client would not have had these damages. So it's important to realize that even doing your best, you could potentially be held responsible, but it also alerts you to the idea that you've got to keep your eyes open, and a home inspector is a good thing to bring into your home. Another issue is drinking. You may have kids that come home and let's say they're in college and they bring friends from high school and the kid is 16 years old and you're like, boy, they've been around the house a lot. I thought they were in the same grade. So they must be, sophomore, junior in college, but no, maybe they're a senior in college and they're not 21 and they drink and, they're drinking from alcohol that you provided, or they're just drinking in your home on alcohol that you didn't provide, but it's in your refrigerator. You can be held responsible for not just the damages to them, but you could be held if they go out and they hurt somebody else. If they drive drunk and they injure somebody else, you can be held responsible for underage drinking that occurred in your home, even though you didn't personally provide that alcohol to that person who was underage. And the same thing is true if you have somebody who drinks habitually. You have parties all the time in your home, and there's somebody who tends to drink a lot and more than they should. You actually, just by having that person who is a known habitual drinker in your home getting drunk and then goes hurt somebody, you have responsibility to that hurt person under Florida's dram shop laws. The same rules that apply to hotels and to bars that I'm just sharing with you now about anyone underage and anybody who's known to be an habitual drinker is your responsibility too, just for owning a home. Of course, medical malpractice is a huge issue. So is legal malpractice. Any profession potentially has malpractice issues that open them up to responsibility. And of course, product design. This is for those of you who have never seen the movie, from The Jerk. This is Steve Martin. He developed glasses that caused people to go cross-eyed, sold millions of them, and then lost everything. And the same thing is true if you are an inventor, even if you have a patent. If your product causes harm, you can be held liable. My dad owned a tire shop. I'm not that old, so the cars he worked on did not exactly look like this. But this is what happened when one of the people that worked in his tire shop failed to put the nuts around the lug. And so the car left the tire shop after my dad put on a new wheel, and the wheel fell off several blocks down the road, causing that person to get into an accident and causing injury that my dad was then held responsible for. So a business that you wouldn't even normally think would have liability has potentially liability. Anytime you're providing a product or service to the public, liability exists. The same thing is true as far as liability for things as simple as hobbies. So this is an example of a client of mine who was the driver of a jet ski, and they were driving on the lake all day, and he was the driver. He was the most responsible of the three kids that were playing that day. He was driving, and two kids were holding on the back of the raft. The very last, it always seems to be the very last run of the day. The very last run of the day, one of his friends said, you've been driving all day. Why don't I drive and you hold on to the raft? And so he did. They switched positions. Well, this kid who was, 17 years old at the time, was the quarterback on the football team. He decided to play a prank on my client and the friend that was next to him on the raft. And he drove going 50 miles an hour towards the shoreline. And right before he hit the shoreline, he made a swift turn. And the raft, and he wasn't using his head, the raft with centrifugal force flew up outside of the lake onto land. And my client, who was a wrestler planning on going to college under a scholarship, flew off the raft, hit a tree, broke his femur bone, lost his ability to go to college, lost his scholarship. His future changed drastically as a result of that. and we sued the parents who provided the jet ski to these young kids, and as under negligent entrustment. So even your hobbies are things that can create liability. Let's talk quickly about damages. So there's three types of damages anybody that's injured as a result of the issues that we just talked about can sue for. One is for medical bills. And even if they have health insurance, the health insurance has what they call a lien on your case. So the health insurance company is entitled to reimbursement through the injured party, let alone any future medical bills. You would be held responsible for that. So past medical bills paid for by health insurance, paid lien from the health insurance company, future medical bills, you're on the hook for. Wage losses and even rehabilitation for wage losses in the future. If your client can no longer, the person can no longer do the job that they had been trained for. And of course, that one that we all hear about so often, pain and suffering. So let's talk about the solutions to these issues, because obviously, as I share with you, these are big problems and you can't always do your best to avoid them, although you should. So one of the ways that you can do your best is to control the damages from these kinds of problems. So I have a picture here of a motorbike. So some of you that are risk adverse would say, boy, that looks like fun, but if I gave that to a 14-year-old, they could do some damage to themselves or others. And that's exactly what happened in a case that I'm representing a client on. The grandfather bought this type of motorbike for their 14-year-old grandson. He went out and he did this a lot apparently within the neighborhood with his friends, and they were driving around fast. It's red, it's fast. They were driving around not following the rules of the road. Well, one of the things that they did was there was two signposts up, and to play, kind of make it challenging for himself, going at a meaningful rate of speed, he went through the signposts. And he probably had done it many times before successfully. This time he didn't do it, and one of the posts hit the drive of the tire, and he fell down. And my client happened to be walking in front of that sign, and he flew off, and the motorbike hit and landed on top of my client, causing significant injuries. And of course, we're suing them because of the negligent entrustment of this dangerous instrument in the hands of the 14-year-old. So damage control is important, thinking through what you're doing. Another, the best way to protect yourself is insurance. People say they don't want to be overinsured because they're afraid of people like me pursuing claims against them. Having appropriate and enough insurance is not going to invite a lawsuit. What is going to invite a problem, though, is not having enough insurance or not having the proper insurance coverage. So in buying auto insurance, these are the things to watch out for. You want to make sure that everybody that's in your household is listed as a driver. So if somebody comes back into your household, let's say somebody moves back in with you, a college student that comes back home and says, I'm taking a semester off. And you're not really thinking, you say, guys, they're going to go back to school. So do I really need to add them to my insurance? Absolutely, especially if they're going to be using your car. The other is a listed car. So you might get a car, and let's say it's not repaired or you don't need it for a couple of months, and you took it off of the insurance because you didn't want to pay the premium on that extra car. You got to remember to put it back onto the insurance policy when it's repaired or you take it back out again. Rental cars. It's important to know that, if you're using your credit card may cover auto accidents. But you also want to make sure that the insurance policy you have does cover rental cars. And you'll even want to make sure that it covers rental cars in other cities or other countries, rather. Let's say you travel to Puerto Rico. Your auto insurance may not cover you in that territory of the United States, because in the contract, it may say we only cover rentals in the continental US. It's not covering you potentially in Puerto Rico and Mexico, renting a car in France. You need to make sure that your contract with the insurance company covers you when you rent a car. In underwriting, when you're filling out that application, it is really important to make sure that you tell the insurance company everything. I know it can affect ultimately the price that you have to pay in premium, but the insurance company, depending upon the amount of damages involved, very well may go back and try to say, you didn't tell us everything, so we're not going to cover you. Had you told us what we now know, we would not have provided you insurance or would have charged you a higher premium. But because you didn't do that, we're not providing you any coverage. And that is a bad time to find out that you do not have insurance coverage. Let me give you a brief example of that. I have a client who was injured when a truck pulled in front of them. That truck had a 14-foot trailer like this, because it was a lawn company, in the back of it. That 14-foot trailer was recently replaced. It was recently bought, and what was there before was a 12-foot trailer. The person in the lawn company that owned it went to the broker and said, hey, I got now a 14-foot instead of a 12-foot trailer. I want to make sure that you're aware of it. And the broker said, oh, no problem. We'll get you new insurance. And he didn't actually say 14 versus 12 because he didn't think that that was an issue. But in the policy, it says we only cover 12-feet trailers. So the insurance company said, we're not responsible for this. Even though it's only 2-foot difference, we told him in the policy that we don't cover 14s, we only cover 12s. In that particular situation, we ended up suing the broker who sold him the insurance under something called an errors and omission policy. But that's the kinds of things that insurance companies will look for to say that they don't have responsibility. And then we know the difference between DP3 versus homeowners. Many people now are Airbnb-ing their homes or their rentals, but particularly their homes. And they got to make sure that their homeowner policy covers Airbnbs. So then the property can maybe be considered to be a commercial building when you're renting it out maybe for a certain number of nights. This is all new. This is new types of insurance issues that haven't been an issue before, certainly not before Airbnb came about. And so it may be necessary for you to get DP3, which covers those type of commercial and rental properties versus an HO homeowner's property. It may be very important for you to look at what kind of your contract says about dogs, because it may say no dogs are covered by this policy, only small dogs, only certain breeds of dogs. Pools are another one. You may be able to get an addendum or rider to your policy to include the pool that you just built. But you don't know that for sure unless you pull that contract. Even better than pulling the contract would be talking to the broker who may be able to direct you to the page, because those contracts are written by New York lawyers at $1,000 plus an hour, and they are fine print and they're 30 pages long. So, you may look at the outline to get to the particular issues that most concern you, or you may ask your broker for guidance getting through it. And of course, if you build a separate building, you want to make sure that that building is going to be covered as well. And then with regard to insurances and autos, ride sharing is an issue. So we're getting a lot of people calling us, finding out that they're not covered because they are now providing ride sharing services. It's not the fact that they're actually doing Uber or providing Lyft services, but if they have people in the car with them, or even if they're potentially going to pick somebody up, they don't even have the fare in the back seat yet, the insurance companies are saying, we're not covering that. That's a commercial policy. You needed to be provided some other type of insurance, commercial insurance. We're not going to provide you in that situation. So anybody driving for Uber or Lyft, beware. This is something the insurance companies are asking about because they know there's a lot of it going on out there. And I get a lot of calls from Uber and Lyft drivers that say, what should I tell the insurance company? And the only thing I can tell them is you got to tell them the truth. I mean, they're going to have to make your own decision about whether to tell them. But God forbid that you lie to the insurance company and then they investigate and find out that you're actually on Uber or Lyft at the time. That can cause a lot of serious problems for you, not just a loss of coverage, but potentially insurance fraud. Umbrella policies are wonderful. So umbrella policies are something that you should consider because they're relatively inexpensive. They require you to have the maximum underlying policy coverage, but then they will provide you additional coverage on top of that. And they're relatively inexpensive. I'm sharing with you all the things that are possible, but there's only so many situations where there's potentially multiple $1-million cases that could wipe you out completely. But it could happen to you, and you don't know if you're going to be that individual. So it's important that you don't want to overinsure, I understand, but you do want to get enough insurance that if a personal injury attorney like me is looking at what you have available, they don't say, you know what, they have a good amount of insurance, but their assets are way up here and their insurance protection is only down here. And my client's injuries are even more than that. And so we're going to go after the assets rather than the insurance policy. So you want to make sure that you have enough insurance to cover your net asset value so that if you're required to fill out a financial affidavit, which in situations where we're requiring the policy limits from an insurance company, we always ask for, you want to make sure that you have enough insurance that I'm going to advise my client that we're going to go after the insurance and not go after the at-fault party's individual assets. So, I had a friend of mine who called because they had put their home into a corporation and they were driving a Maserati with just $10,000 worth of bodily injury insurance. And they called in a panic because they were getting sued and they have to fill out one of these financial affidavits. The thought was that because her asset was in the home, which is the major asset, she had a tremendous amount of equity in the home, was in a corporation, she had nothing to worry about. But then she faced that financial affidavit that said, what companies do you own? And she had this dilemma to face. Did she lie on that financial affidavit, eventually exposing herself to a tremendous amount of liability as well as potential criminal fraud? Or does she just not tell them that? And then, of course, they're going to be scratching their head wondering, how does this woman not have any assets, but she has a Maserati? So you do not want to find yourself in that situation because those kinds of situations cause heart attacks. So make sure that you have enough insurance to cover all your assets so the insurance is much more attractive than going after your retirement savings, your income that you produce, and so forth. Renter's insurance is something that as a landlord you can require, but is also something as a renter you can get liability insurance. It's not that expensive and certainly something worth considering. Of course, there's malpractice insurance. And I mentioned before about anything you do that's unusual. If you have an RV, if you have a pool, if you have boats, make sure that they're covered by the insurance or ask your insurance company for a rider. So what I just shared with you was getting enough insurance to have a really nice moat around your castle, whatever your castle is. You want to make sure that you have protection against somebody coming in and taking everything you have in the castle and the castle itself. And insurance is a great way to do that. In order to add additional protection, though, consider making your assets into a number of different castles. So that way, if they break the insurance barrier, your insurance company denies coverage, or there's not enough insurance coverage there, that if they break through and enter your castle, they can only take a small part or a limited amount of your goods, your assets, and rather than all of your assets. So one of the ways to do that is to consider how you're holding title to your assets. For example, let's take real estate. If you have one spouse that is in a profession that is potentially problematic, a high litigation area, like a doctor, for example, or if you have one spouse who's retired and the other one is still working, or the other one drives for Uber, you might consider issues about who holds a title. The person who's retired is less likely to be involved in anything involving litigation. So perhaps you put them in that person's name. Or it may be more useful to have the asset held by both people in both of their names. And that way, if one person gets sued for something that they did while driving for Uber or at work or during a malpractice or in an auto accident, they cannot take that asset because the asset is held by two people and not just one. Another issue about holding title is not just who, but what. So corporations, there's a number of reasons to have a corporation, but one thing that a corporation does is protect assets. So anything that the corporation does where someone says, I'm suing you, corporation, because you did something wrong, the corporation is the only castle, the only assets that individual can pursue. So holding various assets in different corporations can protect you from litigation and protect various assets that you own. The thing about corporations, though, as an asset protection tool, is that they're expensive. They're expensive because there's an annual fee, which isn't that much. They're expensive because they have to be maintained. You have to have annual reports. And if there's a corporation, you have to prove that that corporation was separate from you. So you have to maintain separate bank accounts. The corporation has to file their own tax return. So it can be very expensive maintaining a corporation for asset protection. Even better than that may be using land trusts. Land trusts are a tool that first came about in Florida through the 1950s. And so when Disney came to Florida starting to buy properties, they didn't want everybody to know that Disney was buying hundreds of acres of property in Orlando, because they were afraid that if other people found out, they would bid up their property or buy land ahead of Disney. So they created a land trust, and they allowed Disney under various names to buy property. So no one knew what Disney was doing until they were ready to announce, we have all this property in the Kissimmee area that we're going to develop. One of the great things about land trusts in particular is that if somebody does a property search on you, they're not going to find your name in a land trust done appropriately. So the trust can be named, for example, as the Kids College Trust. Who wants to sue the Kids College Trust? It could be called the Family Trust, or it could be called the 123 Property Trust. You can call the trust whatever you want. And then the trustee does not have to be you. In fact, it shouldn't be. The trustee can be somebody else. It could be a friend, it could be a bank, it could be an attorney, it could be another corporation, it could be another trust. So land trusts can be great because they can hide your assets. And that way you don't appear as a sitting duck, you don't appear as somebody that has a lot of assets. But the beauty of the land trust is that they're free. Once you learn how to create them, once you learn how to operate them, and I would definitely recommend you consider, if you want to use a land trust, hiring an attorney who specializes in this area, and potentially reading this book by Mark Warda, W-A-R-D-A. He's considered to be in Florida the kind of the guru of land trusts. He provides forms and things, you can do it yourself, but on your first one, I would not recommend it. But since this particular tool is not used that often, it may make sense for you to read about it before consulting an attorney. And you may end up knowing more about land trusts than them. That's okay. You want to make sure that you use the land trust appropriately. But the beauty is, as I mentioned, that each one is free once you create it. There's no cost to creating it. There's just cost in getting an attorney to advise you about creating that first one. And then you file the land trust, and that's it. There's no maintenance, there's no issues. You file the land trust, and then the property, whatever it is, but particularly in this case, land, real estate, is owned by the trust. And you can have 50 of these, 3 of these, 10 of these. And if anybody, like I say, does a search, they will never see your name in property records. They're only going to see the name of the trustee. So the beauty of the land trust, and to some extent corporations, is you can create all these various envelopes. So if somebody looks in the envelope and says, how much is in this corporation? How much is in this particular property? What kind of equity do they have? I'm going to sue them. They're only going to find that one piece of property, because you do not want to be in a situation where all your property is held in one name. and then somebody gets hurt on the property and they sue you, and all of a sudden they can take all of these properties. Whereas if you had done this advanced planning, they would only be able to get one of the properties. And let's say you have equity in that one property, in that one envelope. You could always take a mortgage out on that property. It's a normal thing to do. And that way, what are they really getting? They're getting a piece of property that has no equity in it. A great way to protect yourself. Another way to protect yourself, a great way, is to be in Florida, and you already win on that regard. But I just want to share with you briefly what the laws are in regard to asset protection, just in case you need to, because it should make you feel a little bit more comfortable and know how to use it as a useful tool. So for the reason why O.J. Simpson decided to move to Florida after Nicole Simpson civil trial was because of our great asset protection laws. He had an annuity from the NFL that paid him out regularly. So after the family, O.J. Simpson lost the criminal trial, he won the criminal trial, but he lost the civil trial brought by the family. So he owed tens of millions of dollars to the family, but he didn't pay one penny because he moved to Florida. He put his assets into asset protection vehicles, including this annuity. So he was able, unfortunately, perhaps to play golf all day in South Florida, even though he had this judgment hanging out in front of outside. The same thing that I mentioned to you about annuities is also true of IRAs and 401ks and cash value life insurance. These assets are protected from the claims of creditors. Florida also has a wonderful homestead protection laws. So back in, I believe it was the early 90s, a gentleman by the name of Bilzerian was found guilty of insider trading, and the SEC fined him many millions of dollars. Well, Bilzerian, besides being a criminal, he was also pretty smart. So he realized that I'm going to go to Florida and make Florida my official home. And I'm going to buy I think at the time it was $5-10 million. I'm going to build a very expensive home in the community of Appell. And then I'm going to be protected by the homestead laws that say my home is my castle and nobody with a judgment against me can get to it. And so for several decades, Bilzerian lived in his home. He was able to keep the SEC at bay. He did a number of different things, like he rented part of the house out. He put the property in the name of his kids. He did various things to kept the SEC away for many decades, despite the millions and millions of dollars that the SEC fined him for his insider trading. So your home is protected. So just as I was sharing with you before, if there's a lawsuit against you, and I would certainly, if that was the case, talk to an attorney about these types of issues, an asset protection attorney, you can know that your home is protected from any kind of judgment while you're there. And again, you may, if you have a lot of equity in the home, take out a mortgage on the property and even have less equity available in it. Although with homestead laws, that's not necessarily necessary. And then very briefly, internationalization of assets is something that could be important to you. It sounds, unless you have a large estate, it may sound far-fetched, but it may just be something to keep in the back of your mind that personal injury attorneys are very unlikely to pursue assets held abroad. They're also very unlikely to be able to get the cooperation of the government when they go to pursue the judgment against you in some foreign jurisdiction. So the simplest way to do that would be potentially to own real estate, maybe even an income-producing property in another country. It could be a country that you like to visit, like let's say it's Costa Rica or Mexico, but any real estate outside of the United States is going to be something to consider for asset protection purposes. And finally, I wanted to mention to you bankruptcy. Bankruptcy is a last resort. Nobody wants to go bankrupt. And that's the purpose of all the things that I just shared with you, is to avoid this end result, which is what makes this my last slide. Bankruptcy is a last resort. And because of changes in the bankruptcy law, it's more difficult to file a Chapter 7 than ever. The thing about a Chapter 7, which used to be so nice because it was easier to do, was it wipes away all the judgments against you. So if you had a bunch of medical bills, you could wipe them away and start fresh through Chapter 7. But because this was happening a lot, the rules were changed, the law was changed to make it more difficult. So now other chapters, Chapter 11, Chapter 13, where you have to work with your creditors, so you can't just make them go away, is something that has to be considered, making all the other things I just talked to you about even more important, because you don't have this ACE as much anymore. You could, I mean, Chapter 7 is still available to some, but it's just not available as it used to be to many. But it could potentially be used in the negotiation process. So if you're a personal injury attorney and you have a client that says, you know, if you don't deal with me and settle this for a much lower amount than you're looking for, I very well may go bankrupt, and then you'll get zero because I can file for Chapter 7. I had a client in a medical malpractice case that used that against me. Because of the medical malpractice, my client deserved hundreds of thousands of dollars, but because of the malpractice and other things that he was doing, the Board of Medical Examiners was looking at taking away his license. So my client had to deal with the fact that this person may not have any money going forward because of the loss of his license, and the insurance that he had didn't cover him. He was performing medical procedures, surgeries in his office that the insurance specifically didn't cover. So given that exposure and the idea that something in her mind was better than nothing, the lawsuit was settled for far less. But as I say, because he potentially had the ability, he had no assets to speak of, but because he had the potential ability to file bankruptcy, it caused us to go away at a much reduced judgment or settlement. So with that, I want to see if there's any questions that you have, and look forward to being of help in any way that I can. Thank you for your attention and spending your morning with me.
That was great, Dale. I just wanted to mention something. I do have a umbrella policy, but this idea, people other than insurance people like to say that that policy isn't that expensive. It's not, but they also require you to have larger automobile limits. So in that sense, it does become more than you think.
Deborah's absolutely correct. So given I shortchanged it a little bit, I did say it was not expensive. What is expensive, though, is, as Deborah's sharing with us, you have to generally have, I don't know of any other situation where it's not required, you have to have the maximum of the underlying coverage that's provided by generally that insurance company. So for example, I use Amica, and Amica's top bodily injury liability coverage is $500,000. So you have to have the $500,000 in underlying liability before they will add an umbrella. I can't do 100, I can't do 300. So yes, that is a potentially expensive step to realize that you have to have the maximum underlying policy before an umbrella policy will be granted to you. So thank you, Deborah, for mentioning that.
One question. Thank you, Dale. Great stuff. As it relates to like DUI, if you have a corporate function or a client event and you're serving alcohol and then someone gets a DUI, does it matter whether or not it was paid for by the business or if they paid for it on their own? Does it really make a difference, or is it who's hosting the event? Or
So as I share with you, attorneys are hired to advocate for their client. So the attorney is going to look for the deepest pocket and the available pockets. There's also another issue that if there's some pocket of money that might be available, or maybe the liability is not clear, then it is possible that the other defendants may point the finger at the party that's not there and say, don't blame us, blame that person in that chair who's not here. They deserve all the liability. And that's called an empty chair. So to make sure sometimes that we don't have an empty chair at trial, and then we have a great result from the jury point of view, they just pointed the finger at the only defendant or two that wasn't there, we generally have to sue everybody. And then it's up to the defendant to try to see if they can figure a way out of their potential liability. So know that everybody's going to get sued in that kind of situation where a company has a party, an event. And so there's various areas of potential reduction in liability. So if you have a professional caterer, for example, they're supposed to train the bartender. And so the bartender shouldn't be handing out drinks to somebody that's under 21, somebody who keeps coming back up to the bar and is obviously drunk. There may be a number of drinks, that they say, well, we're limiting you to a certain number. And that happens as a way to try to limit liability. We're giving everybody, 2 tickets. So the limit is 2 tickets, no more. So yes, a company can be held liable even if there is a caterer, even if they have 2 tickets. What if the person came in with their own drink, so was drinking somebody else's drink? The argument can potentially be made that you should have known that that person was being inebriated and was not, somebody should have taken the keys away. So the company was acting negligently and letting that person out the door. You say, wait a minute, I'm doing other things. I'm on the dance floor. I'm not involved in the party. Shouldn't the bartenders that were, hired by the caterer be aware of that? Yes, except that when we get into a lawsuit, as an attorney, we can't care about that. That's kind of, like I say, that's that ethic moral issue. So when you have a corporate function, hiring a caterer and making sure that they have insurance and finding out what their limits of liability are, because certainly if they don't have insurance, that is probably not a deep pocket, could make sense for those types of situations. So like I say, you can do various things to protect yourself from a corporate party, but you do have to be careful. And again, having that insurance is a great first barrier. Any other?
Go ahead. I have a question.
Yeah.
Are investments covered under an umbrella policy? Like if you have different brokerage accounts, or if you're doing stocks online, like my husband, he's doing the stock market a little bit. Is that what he's doing? Is that protected under the umbrella? And also a follow-up on the umbrella is, what is the idea amount of coverage that you should have as an umbrella?
So the umbrella very well can protect not just his stock portfolio assets, but any asset. So it's that umbrella that covers everything. It would cover your home, and it would cover all your brokerage accounts, and it would cover a boat that you may have some equity in, and it would cover rental property, and it would cover your diamond jewelry. I mean, it would cover everything. So that's all those things, including your husband's and your stock brokerage portfolios. All of those things are in the castle, and the umbrella is covering all those things in the castle. So when a lawsuit is filed, then let's say it's filed against you because there was some kind of auto accident. That's when your bodily injury insurance with your auto insurance kicks in. And if the damages being claimed by the plaintiff is high enough, then your umbrella policy would sit on top of that. So in speaking to how much to have, you don't need to have more than whatever your net assets are, because the attorney's thinking, I don't want to go after those net assets because they may disappear, and then I got to try to pull them back in. They're difficult to collect on. The insurance is step one, and if I get it settled, or I get a judgment against the insurance company, that's easy. But if I get a judgment against those assets, then I got to go to step 2 and 3. I got to hire somebody to go after the assets and pay them a 25% or so of all the assets they get against you. So then I'm losing money, and that may take a while. So an attorney is looking to go the easy route, just like water, and that is insurance. The insurance is the easy route. The issue is if your assets are much higher than the amount that the client is looking for, and there's not enough insurance coverage for that. So I'm just going to throw numbers out. If you have a $100,000 insurance policy, or like the person I mentioned to you that had $10,000 insurance, but their home was worth $2 million. And, the person gets injured and the person has, $1 million worth of injuries. I can't go back to that client and say, oh, take the 10,000. He's going to say, I want that 2 million because it's on that financial affidavit. And then that client, if they say, well, they said they don't own anything. Well, that financial affidavit must be wrong. I want you to hire a private investigator and find out why she's driving a Maserati and saying that she doesn't own anything. And that's when we would uncover that she had this corporation that owned all of her assets that she thought she was safe from. So in that situation, 10,000 wasn't enough. An umbrella policy of the underlying coverage of whatever insurance was, let's say it's usually 300 or 500, plus an umbrella policy for $1.5 million would only have made sense. And that way she never would have had to have the heart attack she did in calling me, because it would have, the insurance would have protected her. So I think you only need to have as much as your net worth. The issue comes in when your assets go up a lot and you forget about increasing your umbrella. So if you invested at $100 in Bitcoin, make sure you evaluate where your net assets are and raise your umbrella policy. Again, once you get past the underlying, for an additional 1 million, 2 million, 3 million, 4 million, 5 million, it's incredibly inexpensive relative to the safety it provides to you to get that additional coverage. So get as much as you need based on your net assets and make sure you adjust accordingly.
Okay, thank you.
Any other questions? Looks like there's no additional questions. I'm going to turn it back over to you, Erica.
Awesome. Well,
Have a good day.
That was wonderful, Dale. Very informative. And we did record this session. So if you have anything additional